morning. Please be seated. This is the time set for oral argument in the matter of ALOHA Grading, Inc. versus SCHULTZ et al., our civil number 17-0325. Each side will have 20 minutes within which to present their arguments here this morning. The panel may reserve some portion of that for rebuttal, but it's up to you to keep track of your time in that regard. We have read the briefs. We've been through the record. We've conferenced the case. We have, I think, a good understanding of the underlying facts, procedural history, and the issues that have been raised. So please keep that in mind as you make your arguments here today. We're recording the proceedings both by audio and video. The video portion of the recording will be available on YouTube in a matter of a few days. But because we're recording this, we'd appreciate it as you approach the podium, please identify yourself and your client for us. And with that, appellant may proceed.
Good morning, judges. May it please the court. My name is Sean St. Clair, and I represent the appellants, ALOHA Aquatic Center, LLC, and Taryn Schultz. There are two reasons why the trial court erred in granting summary judgment for the appellee, ALOHA Grading, Inc. in this matter. First, Taryn Schultz was a third-party beneficiary of a release provision in a settlement agreement between ALOHA Grading's predecessor, ATL Holdings, LLC, and certain borrowers and guarantors under loan documents that were held by ATL Holdings at the time of the settlement agreement.
Was she specifically identified in that release document?
She was named as a borrower party in the sense that ALOHA Grading, Inc. was defined as an obligor, and the release provision applied to any of the obligor's members, managers, officers, directors, shareholders, or employees. The record is, there is no dispute that, and it's past or present as well, and there is no dispute that she was a past officer and director of ALOHA Grading, Inc. As a result, she would fall under the definition of borrower parties as that term is used in the release provision, and then the release states that the borrower parties are beneficiaries of the release provision. So she has the right to enforce the release provision just as the obligors do under the settlement agreement.
As a guarantor, is she really a borrower?
Well, the settlement agreement uses the term borrower parties as a descriptive term, but what the release says is that she's released the borrower parties, so anybody that falls under that category of borrower parties, which the record is not in dispute, would include Ms. Schultz as a former officer and director of ALOHA Grading, one of the obligors. They're released from liability under any of the loan documents that are described in the settlement agreement. And that's really where this issue in my mind turns, is on the Superior Court's definition of the term loan documents. The parties down below agreed in the briefing on summary judgment at oral argument that the term loan documents included the guarantee that's at issue in this case.
How are we to take that lack of dispute? Is that binding on how the contract is interpreted or not?
Well, there's two arguments on that issue. So the first argument being that the parties, by agreeing on the term, there was no dispute. If there is an issue with respect to the clarity of the term loan documents. Now, the term loan documents has it describes specific provisions of or describes specific loan documents within the settlement agreement, and it points to those. But then at the end, it has a catch-all phrase, which says, or any other loan documents between the parties. Well, a party to the settlement agreement is Gus Schultz, and there's no dispute in that. Gus Schultz executed the guarantee that's at issue in favor of ATL's predecessor. So that would be a loan document between the parties. That's not a broad, uncommon term that you would find in a settlement agreement or release. Because what you want to do is you want to create a separation between the parties being released and the party that's seeking to hold them liable. And so you find in settlement agreements that you have broad release provisions, broad definitions, which basically say, you go your way, we go our way. So that provision in there is basically to say any of the parties, the borrower parties here under this agreement, who would be liable, whether under the loan documents described in this agreement or any other loan document, they're released from liability. We're going to go our way, they're going to go their way. And you would expect to see that provision in the settlement agreement. Now, when the parties agreed to that term, then if the trial court felt that that term wasn't clear, that there was an ambiguity, then we should have been given the opportunity to, at a minimum, conduct discovery. But if you look at the procedural posture of the case, basically, we briefed the issue, we argued the issue, and there never was any dispute as to the term loan documents. And then we receive a substantive ruling on the motion for summary judgment, which says, well, the trial court said, well, I disagree with the party's interpretation of this term. And as a result, I'm going to enter summary judgment in favor of the appellee or ALOHA grading in this matter. We were denied the opportunity to even brief the issue, to argue the issue, or to conduct discovery. Yes, Your Honor.
Does Superior Court consider cross motions for summary judgment?
There was a cross motion for summary judgment that we filed.
Well, isn't that kind of a tell to the court that all the parties believe that this is ready for resolution without further discovery?
Based upon the facts that the parties had submitted to the court, and one of those facts was the agreement as to the definition of the term loan documents. Had the appellee responded to our cross motion for summary judgment and said, whoa, 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 loan documents don't mean what the appellant is saying that it means, we very well could have done a couple of things. One, we could have conducted a deposition of ATL or other parties to the settlement agreement to find out, well, what does this catch-all provision in this agreement mean? What did you guys intend by this provision? We could have asked the court for additional time for that discovery if we needed it. But we didn't even have that opportunity because we didn't even know that it was in dispute. We argued the case and handled the case based upon what we thought was an agreed upon stipulated fact, which is the guarantee at issue falls under the definition of loan documents. And it was only after the substantive minute entry granting the motion for summary judgment, denying our cross motion, that we realized, wait a minute, there's a dispute on this issue, and it was too late. There was nothing we could do about it.
Was that issue raised with the Superior Court after the issuance of the ruling on the summary judgments?
At that point, Your Honor, we decided to file the appeal to this court, so we did not file any post-judgment motions.
Well, I'm talking about post-summary judgment, not post-final judgment.
Post-summary, we did not file any post-summary judgment motions. I find that it's very difficult to convince a court that's ruled one direction that we should go another direction, and so we felt that procedurally the best avenue was an appeal.
I understand that, but it concerns me always when we're asked to find that a Superior Court judge erred in a certain respect on a point that was never raised with the Superior Court.
Understood. We made a strategy decision to appeal instead of trying to convince the Superior Court that the procedural posture was incorrect or that the ruling was incorrect. And so, we appealed the issue. We, I believe, preserved this issue for appeal in what we submitted to this court. But you're correct, Your Honor. We didn't file any post-summary judgment motions seeking additional time for discovery down in the Superior Court. On the issue of the settlement agreement, not only do I believe we have a procedural issue, but I believe that substantively, if you look at the language of the settlement agreement and that catch-all language, the language is clear and unambiguous, that it has that provision in there for a reason, as I explained before, and it's so that the parties can go their separate ways. And by having that provision in there, I believe that this court could actually find that that provision is clear and unambiguous and remand the case with instructions that judgment actually be entered on our cross motion for summary judgment. The appellee, on the procedural side of things, the appellee has cited two cases to support the idea that a issue of law is something that the trial courts to decide, and you can't have stipulations that are contrary to the law, and arguing, of course, that interpretation of contract is a matter of law. Well, we believe that this agreement, at a minimum, could have multiple interpretations and is ambiguous, especially in light of the fact that the two parties, one of the parties being a party to the contract, is saying opposite of what the trial court is saying as far as the term loan documents. But in both of the cases, if you look at Word versus Motorola and Cook versus Cook, in both of those cases, the parties ultimately were given an opportunity to fully litigate the issue that they were purported to have stipulated to. So in Word versus Motorola, our Supreme Court overruled and reversed the decisions by the trial court and the Court of Appeals. But the reversal wasn't remanding with entry of judgment to be entered. Instead, what the court said is, we believe that both courts utilized the wrong standard of law, and so we're going to reverse and remand for proceedings consistent with our decision, meaning you're going to litigate the case using the correct legal standard now. And so those parties were given that opportunity after that Supreme Court reversal to actually litigate the issue after the court found that they had stipulated to the wrong legal provision or used the wrong legal standard in deciding the case. Then finally, Cook versus Cook is a family law case where the petitioner sought the dissolution of a marriage, but then later amended the petition to seek to void the marriage on the basis that he married his first cousin. And so the trial court allowed him to move forward with that contention that the marriage was void, whereas the respondent was arguing, well, wait a minute, how can you seek one time to dissolve a marriage? Basically, you're affirming it by your original petition, but now you're seeking to void it over here. You've already stipulated, you've agreed to the dissolution and the effect of the marriage and that it was binding. And the court said no, and they were then able to litigate the issue of whether or not the marriage was void under Arizona law. Once again, we've been deprived that opportunity to even have that ability to litigate that issue and have evidence presented on that issue, have the issue briefed. Moving on to our argument under the Arizona's anti-deficiency statutes and the Tank Verde case, this argument has two components. So the first is whether ALOHA Grading's execution of the deed of release resulted in its waiver of its right to pursue a deficiency under the Tank Verde decision. If the court finds that Tank Verde applies to this matter, then ALOHA Grading's claim is barred as to ALOHA Aquatic, meaning we don't need to go any further because ALOHA Aquatic was the borrower. A borrower can never waive their anti-deficiency rights. And so under Tank Verde, if Tank Verde stands, then there is no claim against ALOHA Aquatic because it was the borrower.
But she wasn't the borrower here. She was the guarantor.
ALOHA Aquatic was the borrower, and which is also a defendant in this matter, Your Honor. And so the ALOHA Aquatic actually signed the note. And so they would be Aloha Aquatic would be the borrower. Now, Taryn Schultz is the guarantor.
Right, and she can waive.
And she can waive her deficiency rights under ARS 33-814G. Now, ARS 33-1814G states that a lender waives its right to pursue a deficiency judgment if it completes a trustee sale on property that's 2.5 acres or less, limited to and utilized as a single-family dwelling. Tank Verde took that statute and expanded it to say there was no trustee sale in this case, but we're going to uphold the spirit of that statute.
Well, wasn't that a bargain for exchange, $36,000 for the deed of release and reconveyance?
Yes.
Here, we don't have any kind of similar situation, do we?
Well, I would argue we have a bargain for exchange, meaning there was over $190,000 in equity in a property that was being refinanced.
And the refinance was for improvements, and that was negotiated between AGI and ex-husband. Your client had nothing to do with it, is that correct?
That is correct, Your Honor.
So how did she bargain for the release and reconveyance?
Well, he was a guarantor as well, and so he bargained for the release of the reconveyance. My client was not involved in that transaction, but if you look at the Tank Verde case, you will see that there were borrowers and guarantors. So there were multiple parties in that case as well, and multiple defendants. And now I will say that the record isn't clear as to who was doing the bargaining in Tank Verde, but they released all of the parties in the Tank Verde case. And so there was a quote-unquote accommodation there in this case, because purportedly Aloha Grading owes Gus Schultz funds. And so they agreed, probably in lieu of Gus Schultz pursuing his claim against Aloha Grading, that they would release the deed of trust. But that is a bargain for exchange. There was something provided or a negotiation that took place for the release. And if you look at the language in Tank Verde, the last sentence of that case is the holding of the case. Now, the facts show that there were actual funds received in that case, but the last sentence is the holding, and the last sentence only requires that the deed of release be executed and that there be no agreement with the borrowers in that case for them to remain liable for the deficiency.
And how do we know that there wasn't an agreement since your client wasn't involved in the negotiation?
I'm sorry,
How do we know that there wasn't an agreement for the release and reconveyance between the parties in privity? You are third-party beneficiaries, so how do you know what was going on?
Well, I believe under Tank Verde, the agreement needs to be directly with my clients in that situation. There may have very well been an agreement with Mr. Schultz on that, and they did, in fact, release the deed of trust, but my client never signed anything, and there's nothing been presented in the record showing that my client continued to remain or agreed to continue to remain obligated after the release of the deed of trust. At the end of the day, these statutes are designed to protect borrowers from financial ruin, to protect against artificial deficiencies. There was $190,000 available in a piece of real estate in which the lender had a secured interest. The lender released its lien against that property and instead is pursuing the financial ruin of my client, filing a lawsuit to seek the financial ruin. The lender wasn't looking out for their own financial interest over there. If they were, they would take the $190,000 and call it a day. Instead, they have a beef for my client, and so they're acting outside of really their own self-interest in pursuing my client for a judgment to either force a bankruptcy or otherwise and ruin her financially to pursue her other assets to recover the loan balance. And that's what Tank Verde is designed to protect against. And, you know, the other anti-deficiency statutes that we have, such as ARS 33-814A, which is designed to guard against artificial deficiencies. Unless your honors have any further questions, I'm going to reserve the remaining time for rebuttal.
Thank you, counsel. Mr. Proper.
Good morning. May it please the court, my name is Jeff Proper, and I'm here representing the appellee in this case, the plaintiff in the underlying action, ALOHA Grading, Inc. I think it's fair to start with the argument of what took place before the trial court. There has been contention that there was a stipulation entered into between counsel and the court that somehow is binding on AGI that made the guarantee part of the loan documents. And by that I mean the defined term in the settlement agreement, loan documents. Our position in oral argument before the trial court was quite frankly incorrect. And the good news is that I think the trial judge got it right in spite of counsel, and we each argued our respective positions. Remember that the motion for summary judgment that we originally filed was very simple, and it said, look, we have a promissory note and a guarantee, and we simply sued for the balance due under the guarantee, to which there has been no real dispute. So the argument in front of the trial court centered around a number of things, including loan documents, including whether or not the loan documents contained an ambiguity and whether or not the court would be required to hold an evidentiary hearing to determine that ambiguity. The trial court raised that issue on her own during the course of the oral argument. The interpretation of the loan documents is particularly suited for the trial court by law. If the trial court finds that there is no ambiguity, the interpretation of those documents is for the court. And I think that's kind of where we are at this juncture in the appeal. It's clear, as we see it after the oral argument and the court's opinion, that the loan documents relate to an agreement between AD LLC, in other words, ALOHA Development LLC, and ATL, the lender. ALOHA Development is named as the borrower, ATL is named as the lender, and every single thing in this settlement agreement, except paragraph 2.1, relates to that particular transaction. 2.1 is the only provision that deals with what happens with ALOHA Aquatic and the guarantee that was executed by SCHULTZ. My client paid, or ALOHA Grading paid, $138,000 and some change for the right to receive the assignment of the ALOHA Aquatic loan documents. It is the only provision in this entire settlement agreement that relates to ALOHA Aquatic and the assignment of those very specific documents that are contained in paragraph 2.1. So it's our position that the trial court's analysis of this agreement is correct, that the agreement is otherwise clear and unambiguous. The interpretation of that agreement is for the trial court to determine as a matter of law, and she was correct. To move on to the issues related to the applicability of the anti-deficiency statutes, they clearly don't apply in this case. The only way that you can backdoor some application of the anti-deficiency statutes is to use the kind of what is boilerplate language in the deed of release and reconveyance. There is no question that this loan is not a purchase money loan. There is no question that Terrence Schultz is a guarantor. There is no question that the ALOHA Grading in this case could have chosen to foreclose judicially, which takes this totally outside the applicability of the anti-deficiency statute. So the only way that the appellant even has an argument in connection with the anti-deficiency statutes is to somehow say that that provision in the deed of release and reconveyance under some stretch of the Tank Verde case somehow bars our right to seek any additional sums against either ALOHA Aquatic or the guarantor Terrence Schultz. And we've given you the pain management case and the Dykes case, all of which basically allow a claim under the original obligation, regardless of whether or not the lien of the deed of trust has been released in this case. It's clear that there was no consideration, no monetary consideration paid to AGI for the execution of that release. The trial court had all of the information before it necessary to make that determination. So I don't think the Tank Verde case applies for the reasons that we've set forth in our briefing and the cases that are cited in our answer brief.
Counsel, what's your response to the argument that while there may not have been monetary considerations of bargain for exchange, and there were other rights either compromised or given up that could constitute consideration? First
of all, there's no evidence that there was any consideration of any kind paid to ALOHA Grading for the execution of the release. There was an affidavit declaration by Mr. SCHULTZ with respect to that transaction. There were documents that were provided in connection with that transaction, and there is no suggestion that ALOHA Grading received some type of consideration for its release that would flow through to Taryn, who was not a party to any of this. So, while I appreciate that we think of consideration in terms of dollars, and sometimes consideration involves other things, which is real consideration, in this case, it's clear that this was nothing more than an accommodation to Mr. SCHULTZ, who was refinancing the property to eliminate a prior lien that existed.
And you, I'm guessing, disagree with Mr. St. Clair's suggestion that his client was a third-party beneficiary of that transaction?
She's not a third-party beneficiary of the transaction that occurred after the settlement agreement. A third-party beneficiary of an agreement between Mr. SCHULTZ and ALOHA Grading. I don't know how she becomes a third-party beneficiary of that.
What about the settlement agreement?
Well, she is, by definition, most likely a borrowing party. The court so found. But again, the borrowing party does not include any obligations that she has other than under the loan documents, which are defined in the beginning of the settlement agreement, page 2, in recital E. So the fact that she is a third-party beneficiary of that provision of the settlement agreement only applies to releasing her insofar as it relates to the loan documents, which don't include this specific guarantee under the ALOHA aquatic documents. It seems a little anomalous to take paragraph 2.1 and have my client pay $138,000 and some odd dollars to specifically receive the ALOHA aquatic documents, the promissory note, the guarantees, and all those documents, and then provide that after paying $138,000 to receive them, he somehow gets absolutely no benefit from the payment of that money and the receipt of those documents. So I think you have to take a look at paragraph 2.1 as kind of standalone, and it is the only thing that relates to this transaction that we're here on today. And therefore, I don't think that it would be reasonable to effectively have that provision 2.1 in the settlement agreement and then write it out because the parties are released. You have to give effect to all parts of this document. That means you have to take a look at paragraph 2.1 and see how it dovetails into 4.1 and 6.7 and find that it's a standalone provision and was not released by any other provisions of the settlement agreement. The court has no other questions. I have nothing else to say.
Thank you, counsel.
Thank you.
Mr. St. Clair.
There's 2 points I want to address on rebuttal. First is the argument that if ALOHA Grading had conducted a judicial foreclosure, since this was a non-purchase money loan against residential property, that it could have pursued Ms. Schultz and Aloha Aquatic for the deficiency, that wouldn't have happened because they would have recovered a sufficient amount from the sale of the property to pay the loan amounts, or at a minimum, any deficiency would be substantially reduced from the recovery from the property, which gets back to my original point on what Tank Verde is designed to guard against and what we have as far as the language in the CSA Loop 101 LLC case, as well as the Arizona Bank and Trust case, which is these statutes are designed to protect borrowers from financial ruin. The whole idea of these statutes don't work very well if a lender's not pursuing its best financial interest. And that's what we have here, and that's what Tank Verde in those cases are guarding against. Finally, as far as the benefits that would have been received from the conveyance of the or the assignment of the loan, we would be speculating as to what those benefits are, but there could be a number of benefits. One, you may not want the deficiency or forgiveness of debt during that time period, and so maybe you want to take the forgiveness later on because of the fact that you're having other forgiveness of debt that takes place in the settlement agreement. There could have been you wanted to keep that Aloha Aquatic note for one reason or the other, but we would be speculating, which gets back to my point of needing discovery to figure out these issues.
Thank you, counsel.
Thank you.
We appreciate the arguments made here this morning, as well as the briefs submitted in this case. We're going to take this under advisement and issue a written decision in due course. With that, we stand adjourned.